Supreme Court of India Suresh and others versus State of Madhya Pradesh decided on November 24, 2023 SEC Online SC 1533 Facts of the case. Appellant filed the petition before the High Court for FIR registered against them for offences punishable under Sections 420 and 120B of IPC and Sections 3 and 7 of the Essential Commodities Act, 1955, for short, the EC Act. The High Court has dismissed the petition. Findings of the court: FIR was registered on October 14, 2021 and the charge sheet was filed on 11 February 2022. The expert's report on the nature of the liquid found in the seized tanker has not been produced. The entire foundation of the charge sheet is that there was a hydrocarbon mixture in the seized tanker, which looks precisely like petrol and diesel and smells like petrol and diesel. Along with the charge sheet, the respondent did not produce an expert's report regarding the precise nature of the liquid in the tanker. Samples were sent more than 2 years back for testing, and a report has not yet been received. In the absence of the report, taking the charge sheet as it is, no material is placed on record to show that the liquid in the tanker was neither diesel nor petrol but a mixture of hydrocarbons. Unless there was a material forming part of the charge sheet to show the nature of the liquid, no offense is made out. Now, it is too late for the state to file a report after a gap of more than 2 years. The respondent has not attempted to get the report during the last 7 months. Even an adverse inference can be drawn against the respondent. Hence, the continuation of the prosecution will be an abuse of the process of law. The appeal succeeds. The FIR number 727 dated October 14, 2021, registered with Kishanpura District, Indore, and the consequent charge sheet filed thereon are quashed and set aside.